My dear friends and family, today I want to clear up a very common misunderstanding that I am seeing among skilled workers visa holders, especially care workers and senior care workers. Many people come to see me and say, my employer license has been revoked. It's a very common scenario nowadays. And I want to switch to a new employer, but I have been told I must work for the new employer for at least 3 months before they can issue a certificate of sponsorship. In many cases, that is not correct. Let me explain. The 3 months employment requirements mainly affects care worker and senior care workers under SOC code 6135 and 6136. If you are already in the UK working as a care worker or a senior care worker, you are moving to another employer in the same occupation, you normally do not need to show 3 months of employment before a new CoS can be issued. So that's the misunderstanding people do. The same applies if you originally entered to the UK under the previous occupation codes 6145 or 6146 and are continuing in the same type of care role. In those circumstances, the 3 months requirement generally does not apply. However, the position is different if you moving into a care worker or a senior care worker role from a completely different occupation. For example, if you're currently working as a chef or a restaurant manager or warehouse worker or another occupation, you now want to switch into a care worker role. In that circumstances, your sponsor usually need to evidence that you have worked for them at least 3 months before assigning a CoS. The same issue often arises where someone is on the visa route or is a dependent, wants to move into a care worker role for the first time. Another important point that many people misunderstand is that if you're switching to most other skilled worker occupation outside the care worker and senior care worker categories, there is generally no requirement to complete 3 months of employment before CoS can be issued. For example, if you're moving from a care role into a management position, hospitality role, constructions role, or many other skilled worker occupations, the 3 months rule does not apply. The key message is very simple. The 3 months employment requires is not a generally skilled worker visa rule. It mainly relates to care worker and senior care worker applications where a person is entering that occupation from a different category or a different occupation code. Please do not assume that every employer requires 3 months of employment before CoS can be issued. Every case is different. If you're unsure about your status, unsure about your situation, get proper immigration advice before making an application. Come to see me. I'm here to help you. Have a great day, guys. Visit my YouTube channel, Zahid Azad. Have a great day. Bye-bye.